Hi. If you're a professional practicing in the field of insolvency, bankruptcy and the restructuring of corporate finance, then this short video could make a world of difference to your practice. An entirely niche and continually evolving area of practice has emerged with the coming of the Insolvency and Bankruptcy Code, 2016. Research on cases pending before the NCLT and NCLAT require a thorough understanding of the intricacies and merits of every individual matter. We're only finding a few authoritative precedents. Using traditional methodologies like keyword search on general points of law does not suffice. Traditional keyword search, although useful, is usually time-consuming, inefficient and limited in scope, especially so in light of the complexity that is inherent to insolvency matters. This happens because keyword-based searches retrieve results based solely on the occurrence of a particular search term in a case, regardless of the context in which it is present. As a result, dozens of irrelevant cases are thrown up and a significant amount of your time is wasted. Issue-wise fragmentation of research means that researchers spend a large part of their time going through excerpts from various cases, trying to find one that matches the factual context of the research document. To address these problems, we came up with CaseIQ, a unique system of contextual retrieval, which uses artificial intelligence in order to analyze the facts and legal issues in an uploaded document. Working on the context retrieved from the uploaded document, it retrieves case law applicable to the detected legal issues and facts, thus automatically showing you precedents that are relevant to your research. To illustrate this further, we will present a typical use case derived from an extensive study we conducted comparing the efficacy of traditional keyword search with CaseIQ-assisted contextual search. The study recruited several practitioners in the area of insolvency and bankruptcy conducting research trials on a curated set of IBC matters using both the methodologies. The use case involves a judgment passed by the National Company Law Appellate Tribunal. The legal issues raised before the bench include maintainability of the petition, the question of oppression and mismanagement within the company, an application under Section 45 of the Arbitration and Conciliation Act 1996, seeking a direction to refer the parties to arbitration in accordance with the shareholders' agreement, etc. We also noticed that the impugned order was passed by the NCLT in its judicial capacity. Our researchers uploaded the entire 22-page document onto CaseIQ. The aim was to find judgments that matched not just the legal, but also the factual context of the uploaded document, so as to ensure that they are authorities applicable to our case. Let's quickly examine the results retrieved by CaseIQ. The first result is the judgment uploaded by our researchers, as it is the judgment having the maximum in common with the context of our research. The second result is a judgment given by the High Court of Bombay, where the question of maintainability has been raised as a preliminary objection. Reading further, it is evident that the facts in this case also deal with the existence of an arbitration clause in the shareholders' agreement. This is definitely a judgment matching the context of our research. Similarly, the next judgment in the list also deals with the question of whether the question of oppression and mismanagement can be dealt with by an arbitral tribunal. Thus, this is a case that covers each one of the legal issues present in the uploaded document, from maintainability to oppression and mismanagement in the existence of an arbitration clause. Scrolling through the list, it can be seen that the judgments retrieved were dealing with a question of maintainability, not just generally, but with respect to a company petition, where there existed a prior agreement to refer matters to arbitration. Also present in the list are many Supreme Court judgments which have been cited repeatedly in the context of the legal issues present in our research. Precedents that would have taken our researchers hours or even days to find, were retrieved in the first iteration by CaseIQ. Having gained a general idea about the results that were retrieved, our researchers proceeded to use the many filters and analytical tools available on CaseMine's to further narrow down the results and check on subsequent references and follow-up for these precedents. Moving ahead with the comparison, the same practitioners used the keyword method to find relevant case laws. It was immediately clear that carrying out comprehensive research required several iterations of different combinations of keywords, or large, Boolean queries, to reach the level of quality of precedents that had been found with CaseIQ. Breaking the judgment into searchable keywords, some propositions our volunteer lawyers entered included maintainability of company petition, oppression and mismanagement, Section 45 of the Arbitration and Conciliation Act 1996, direction for referring parties to arbitration, judicial and adjudicating authority of NCLT, judicial authority not appealable under Companies Act, etc. Let us examine the results quickly. Searching for the keywords maintainability of company petition, retrieved various cases from different high courts and the NCLAT. Most of these results dealt with the winding up of a company, and did not match with the facts, as the only reference point was the keyword entered. Similarly, entering various other propositions like oppression and mismanagement or judicial and adjudicating authority of NCLT, only retrieved cases related to that single legal issue. Our researchers were unable to find cases that dealt with all the legal issues collectively, hence missing out on strong contextual matches. Moreover, most of the precedents found were partially applicable at best. Our researchers felt that CaseIQ's context retrieval capability had enabled them to efficiently find relevant precedents in a fraction of the time that the same exercise would take via the keyword route. Many of them were also of the opinion that they might even have missed out on certain clinching precedents that CaseIQ retrieved. In conclusion, when we restrict the scope of our research to certain keyword propositions, we automatically exclude many other paraphrased variants of the same propositions, simply because they did not contain those particular search terms. For example, searching for only breach of contract might not retrieve valuable precedents on remoteness of damage, even though the two propositions are inherently linked. Additionally, this method of issue-wise fragmentation of research meant that our researchers spent a large part of their time going through excerpts from various cases, trying to find one that matched the factual context of the document. In comparison, most matters that we come across in the real world contain an interplay between multiple complex legal issues and facts. Consequently, this translates into numerous repetitive steps of trial and error, where we try different combinations of different keywords. When dealing with complicated questions of law as well as fact, especially in the case of insolvency and bankruptcy where the law is ever evolving, the need of the hour is a system of contextual retrieval that understands the thought process involved in your research. The time that you save on research is the time that you can further utilize towards the various other aspects of your practice. Got questions? Just drop us a mail at support@casemine.com. CaseMine, the legal revolution is here.